Welcome to Court Helicopter Explainer, a very explosive issue about the Tuju and Dari Business Park issue. The question is, Tuju borrowed 930 million, roughly 930 billion. Now the bank wants billions. Is it fair? Is it just? What does the law talk about the duplum rule? Those ones who are there know of a member of parliament called Joe Donde. Joe Donde pushed for this to be included into the laws of this country. Forget about it. Let's go to Fuliza. How do they charge their interest? The digital platform. How do they charge their interest? You borrow 1,000 shillings. In less than 2 months, that money has gone to 5,000 shillings. What is the interest rate in the digital platform? Have you calculated how much you charge? These guys charge interest per day on your kabambi. So today, we get you the answer. Because the Kenyan law protects you against what we are seeing in Tuju. Tuju's mistake is that the loan was taken from Uganda and the law applicable was the UK. Had Tuju's agreement indicated that the law applicable is the Kenyan law, this is the law, the Banking Act of Kenya. That is cap. It is cap 488 of the laws of Kenya. Section 44A, which says, an institution, that is a bank, shall be limited in what it may recover from a debtor in respect to an unperforming loan to a maximum for A. The bank is allowed to recover the principal owing when the loan becomes non-performing. B, and that is the most critical, 44A subsection B, interest in accordance with the contract between the debtor and the institution, not exceeding the principal owing when the loan becomes non-performing. So if you took a loan of 30 million shillings and you have repaid 20 million shillings, you are remaining 10 million shillings. If the bank wants to sell their property, they cannot exceed 10 million shillings times 2. Not more than double what you borrowed. Once the interest reaches times 2 what you borrowed, the duplum law applies there. No more. This was the question that was put before the Commercial and Tax in the Milimani High Court, Commercial and Tax case number E144 of 2023. Judge M.A. Otieno, judge, had a position to do this. This is the famous case of the lawyer, our late senior counsel, my lecturer at the University of Nairobi, Charlo Bobu. He was shot dead. This decision came after he had been killed by gunshots. May God rest his soul in eternal peace. But this decision was decided by the same judge who has given Tuju a lifeline. The same judge has told the auctioneers, stop, don't sell, don't transfer. Is he likely to save Tuju's property? Here is the facts of this matter. So follow probably Tuju's salvation has come. The facts of this matter is that Bobu, the late, was advanced a loan of 11 million shillings to be repaid within 6 months at an interest rate of 15% per month. Per month, 15%. If there shall be a late payment, the late payment will attract 5% per week. 5% per week. This amount. Bobu asserted that he had been given 11 million shillings. He had repaid 24,600,000. But these guys, the bank was still demanding 69,495,599. Gentlemen, let us be realistic. Chalo was given 11 million. He paid 24,600,000. Still, these guys wanted 69. That is roughly, he was given 11 million. He was supposed to pay over 90 million shillings. Could you imagine? But this is not a movie drama. What happened in court? Let us see what happened in court. So the question why the judges agreed with Bobu and declared this duplum law to apply. Listen what the judge said. In the case of Margaret Njeri Muiruri versus the Bank of Baroda, Kenya Limited, paragraph 36, here the judges in that case what they said. Nevertheless, courts have never been shy to interfere with or refuse to enforce contracts which are unconscionable, unfair, or oppressive due to procedural abuse during formation of the contract, or due to contract terms that are unreasonably favorable to one party and would preclude a meaningful choice for the other party. So the courts are looking at the terms of the contract. They will apply what is called first, the bargaining must be oppressive. Did Tuju's bargain between Tuju and the bank oppressive? Definitely. 2, does it bring shocks and concerns to the court? Everybody is shocked how Tuju's amount reached that place. And lastly, is the victim Tuju suffering from certain types of bargaining weaknesses? Yes, Tuju could not bargain. And thirdly, did the bank act unconscionably in the sense of having knowingly taken advantage of the victim? Did the bank take advantage of Tuju's need? Yes. This is what the court says. In Kenya, the present case of 15% per month with a compounded interest of 5 weekly penalty translates to an annualized rate exceeding 400% when compounded. In my late Bobu's court, the court found out that the compound interest was 400% annually. That is, if he took 11 million per year, he was to pay that 400 times on top. The court could not agree with this. And the decision of the court, he says, in the duplum rule is concerned with public interest, and its key aim was to protect the borrowers from exploitation by the lenders. And therefore, the borrower, Bobu, and the borrower, Tuju, are likely to survive. This one, as I said, it is the same judge who saved Bobu. Tuju, the same judge, has stopped the transfer. What did the court say? In the final determination, a declaration that the interests and penalty clauses in the loan agreement dated 27th January 2021 between the plaintiff Bobu, the late, and the first defendant are unconscionable and therefore illegal and unenforceable. 2, a declaration that the plaintiffs have fully satisfied the loan facility advanced by the first defendant. And lastly, an order directing that the first and second defendant to discharge and retransfer title number IR 8302/LR number 15065/64 to the second plaintiff within 30 days of this judgment, failing which the Deputy Registrar of this court shall execute all necessary transfer and discharge documents to the effect of the transfer, and that the courts have interpreted Section 44A under the duplum rule that if you have taken 10,000, the maximum you can pay is 20,000. If you have taken a loan of 5,000 shillings, the maximum you are going to pay is 10,000 shillings. If your loan, this question has gone to university students, help, you are given help, loan of 70,000 shillings at the entry of first year. You finish fourth year, you tarmac for 8 years, you get a job, you find the interest. You have been told you are given a loan of 70,000 shillings as a help loan. Now we need 700,000 shillings. The duplum loan is now applicable in Kenya. If help loan was 70,000, the maximum you can pay is 140,000 shillings. Those ones who have been given advanced any money, Shylocks, will advance you any money. Now you know the maximum you can pay is ×2. Just tell them, Wakili Dan Omari with court helicopter, they told you Section 44 of Cap 488, that is the Banking Act of Kenya, you are not supposed to pay more than twice what you borrowed. And that is why I'm very, very certain Tuju will survive, because although he never argued his case in the Kenyan courts, there is what the laws here, they are saying public policy. What is the public policy? A public policy is to dispense justice in a manner that is morally upright. Tuju is going to survive, and this will give a shock to banks. But I've advised from Kenyans, many of you are doing a lot of business with the Chinese. The contracts you write with Chinese suppliers is normally hidden, that the law applicable is Chinese law. The law applicable is the Dubai law. The law applicable is the Japanese law. My friend, the duplum law is not in UK. The duplum law is not in China. You will be slaughtered. Insist every other time, whenever you are dealing with a foreigner, put that the law applicable is the Kenyan law. We have seen this decision. The first duplum law was in the Supreme Court of Appeal of South Africa. This is where the first decision, that is case number 205 of 96, it was the Standard Bank of South Africa Limited versus Ornet Investment, where that was in 1997. The judgment of South Africa is the landmark. This is the Constitutional Court of South Africa. It declared that as the law that should be applied. The same thing went to the Court of Appeal of Kenya in Nairobi. That is Civil Appeal number 252 of 2009 between Kenya Hotels Limited versus Oriental Commercial Bank. Three judges of the Court of Appeal, Justice Ouko, Justice Katembu, Justice Kantai, in a judgment that is dated, dated the 25th October 2019, agreed that if you borrow from any bank, the maximum the bank can take is ×2, not more than ×2. This week, several banks in this country, leading banks, declared serious profits. Helicopter is showing you how banks, Cooperative Bank, Equity Bank, KCB Bank, they declared serious profits. But Wakili tells you, any loan you take from the bank, make sure you do not get charged interest beyond ×2. Keep watching, as we are always on the alert. We have been following the Tuju story, and today we have given you the solution that Tuju's loan is going to be declared illegal because it does not follow the duplum rule. Keep watching.